Hello aspirants, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis on different topics. Get ready for the dictation. The moot point arising for consideration in the present appeal is whether, in the case of certain witnesses being declared as protected witnesses in the exercise of powers under section 173 within bracket 6 of the Code of Criminal Procedure 1973, read with section 44 of the Unlawful Activities within bracket Prevention Act 1967, by the trial court can the defense seek recourse to the remedy under section 207 and section 161 of the code for obtaining copies of redacted statements of these protected witnesses. An application under section 207 of the CRPC was filed by the appellant before the trial court praying for a redacted copy of the statements of protected witnesses A1 to A5. This was resisted by the respondents herein on the ground that the said application was not maintainable for the reason that whether copies of such statements needed to be furnished to the accused already stood decided by the trial court in terms of its order dated 1/6/2021. It was contended that Section 207 was conditional upon Section 173 and could not supersede it. The right of the accused to be supplied with all material as envisaged under Section 207 could thus not be interfered inferred to be absolute, which was quite evident from the reading of clause within bracket small 3I of Section 207. In addition, it was contended that there was no power of review under the provisions of the code, and the prayer of the appellant would amount to seeking review of the earlier order. The trial court allowed the application of the appellant while observing that it was amply clear that the prosecution was duty bound to provide the copies of the statements of protected witnesses to the accused in order to provide a fair trial. Further, the order did not restrict or inhibit the powers of the trial court under the aforementioned sections. It was opined that the object of the application of the prosecution was with the sole purpose of declaring the witnesses as protected witnesses, and nowhere did the order opine that the accused were precluded from obtaining the copies of the statements of those protected witnesses. On the aspect of a review power being exercised by the trial court which was not within its jurisdiction, it was urged that the first direction to designate certain witnesses as protected witnesses was in the absence of the accused. That was a distinct nature of proceedings. Those proceedings could not take away the right of an accused to be supplied with witness statements, as the objective was only to protect the witnesses and not to take out the whole statement out of the purview of Section 207 of the CRPC. The second order, dated 11/9/2021, was to fulfill the mandate of Section 207 of the Code, subject to the precautions to be taken in that behalf. Lastly, it was sought to be urged that no appeal was maintainable before the High Court. Appeals against interlocutory orders are barred under Section 21 of the NIA Act, which would equally apply to the prosecution and the defense. On a conspectus of the aforesaid legal position and the limited contours of the facts required for determination of the issue, we are of the view that the provisions of Section 173 within bracket 6 of the Code, read with Section 44 of the UAPA and Section 17 of the NIA Act, stand on a different plane with different legal implications as compared to Section 207 of the Code. We may also note another aspect arising from there being no appeal against an interlocutory order. This aspect somehow has not been dealt with by the High Court, possibly because it opined that the latter order amounted to a review of the earlier order. The appellant had not challenged the earlier order dated 1/6/2021 and could not have done so. Similarly, the latter order could not have been challenged in appeal by the respondents, being in the nature of an interlocutory order given the provisions of Section 21 within bracket 1 of the NIA Act. Having said so, we also come to the order passed by the trial court on 11/9/2021, which has been cautiously worded. The order has not only permitted redaction of the address and particulars of the witnesses which could disclose their identities, but has further observed, as noted aforesaid, that even other relevant paras in the statement which would disclose their occupation and identity could be redacted. Thus, a wide discretion has been given, and that too for the special public prosecutor to take a call. There could thus have hardly been a grievance raised by the prosecution in this regard. On query to the learned counsel for the respondent as to how this order can in any manner prejudice or have the propensity to disclose the identity of the witnesses or their families with the possibility of harm being caused to them, there has really been no answer. We believe that the order dated 11/9/2021 is both fair and reasonable for the prosecution and defense while protecting the witnesses and not depriving the defense of a fair trial with the disclosure of the redacted portion of the testimony under Section 207 of the CRPC. The result of the aforesaid is that the impugned judgment of the High Court dated 11/10/2021 is set aside and the impugned order of the trial court dated 11/9/2021 is restored. The appeal is allowed, leaving the parties to bear their own costs.